Asylum. Asylum is a form of protection that is available to an alien who is present in the United States, even if that alien doesn't have status. You can enter the United States illegally and you can apply at one of the 8 asylum offices around the United States. There are 520 asylum officers in the United States. They're currently supplemented by about 100 refugee officers. We'll get to that in a second. In order to be granted asylum in the United States, you have to show that you have a well-founded fear of persecution on account of your race, your religion, your nationality, your membership in a particular social group, or political opinion. All of this comes out of the Refugee Protocol of 1951, which we did not sign. However, we have acceded to the 1967 addendum to the 1951 Protocol. And so we are an asylum granting country, as are most of the countries in the Americas. We'll talk about that in a second, too. Again, 4 of these 5 bases are pretty straightforward: race, religion, nationality, and political opinion. When people talk about asylum, they often call it political asylum, the idea being that you have fled to the United States, you've fled to a different country because you have political differences. But in reality, asylum actually arose out of the treatment of the Jews by the Nazis during World War II. And all of our asylum laws are actually really supposed to be modeled on that. That there is some immutable characteristic or some characteristic that you shouldn't be expected to change, like your religion or your political opinion. And that someone wants to harm you on the basis of that immutable characteristic. There are 2 different kinds of asylum that you can get in the United States. There's affirmative asylum, where you go to one of those 8 asylum offices around the United States. They're everywhere from Los Angeles to Newark, New Jersey, to Houston, Texas, spread all over the United States. You go in there, you say, look, I'm here illegally, or I'm here as a tourist, and I need to get asylum. You file a form called an I-589, and an asylum officer will adjudicate that application. If it's granted, you get granted asylum. You get a status that will put you on a path to citizenship. After 1 year, you can become a lawful permanent resident. 5 years thereafter, you can become a citizen. The other form of asylum is called defensive asylum, and that is when you are arrested by ICE or arrested by CBP, and you assert that I need to you get put into proceedings. You're charged with removability for being in the United States illegally, for having entered illegally, for being an overstay. And you admit that that happened. In my court, probably 98 to 99% of all people admitted that they were removable as charged. And a surprising number of them then applied for asylum, because you can apply for asylum as relief from removal. Same standards, same basis. Let's talk about affirmative asylum for a second. The number of affirmative asylum applications has mushroomed in recent years, with 56,912 in FY 2014. In FY 2017, that had grown to 142,760. Probably a lot of people realized that things had changed under the Trump administration, that individuals who are not a priority for removal under the Obama administration may in fact be priorities for removal under Tom Homan and the Trump administration, and therefore they wanted to get the benefit of asylum. Like I said before, asylum will allow you to, if you get granted, it'll put you on a fast path to citizenship. It will also allow you to immigrate your relatives to the United States. They can follow to join you in the United States. So it's actually a very valuable status to have. It's also very difficult to obtain. Well-founded fear is not a very high standard. 10% or less likelihood that you're going to be persecuted on account of one of those bases is enough to actually get you the status. But again, it's very difficult to show that someone's going to harm you on account of one of those 5 factors. As I noted before, 4 of the factors are pretty straightforward. The 5th one is a wild card. Membership in a particular social group, what does that mean? When they drafted the 1951 protocol, they intended it to be just like the other four, an immutable characteristic, a very defined thing. And again, they were basing it on the treatment of the Jews by the Nazis during the Holocaust. It hasn't stayed that way. In a decision that was issued many, many years ago by the Third Circuit, drafted by then Judge Samuel Alito of the Third Circuit, he stated that a particular social group could be any group that included two or more people. In my court, we would often see these claims be reverse engineered, I like to say. People would come in and they would say, the gang wants to recruit me. Gang recruitment is not generally a ground for asylum. Another category of individuals that was very commonly placed within this group were domestic violence victims. Regrettably, domestic violence is very common in certain parts of the world. It's more common in certain parts of the world than it is in others. And I don't say that to characterize anyone. It's just cultural norms are different around the world. Anybody that does immigration will tell you that. And that actually is the basis of many Central American domestic violence claims. This is a macho culture. People accept this in my country. The government will not protect me. Generally, if you look at the country reports for each of the countries, the main three countries from which these claims come, El Salvador, Guatemala, and Honduras. If you look at the laws in those countries, domestic violence is actually an offense. And in my court, often the police were called, but often the police couldn't actually do anything in order to stop an individual who was hell-bent on engaging in domestic violence. The other issue is that an individual who engages in domestic violence doesn't generally do it on anyone other than a domestic partner. So it is domestic violence because it takes place in the home. That individual does not act against his next door neighbor's wife or husband. It is a criminal act that is directed at one individual person. However, in a case that was issued by the Board of Immigration Appeals about 4 years ago, there were a number of concessions by ICE. One was that a woman was a member of a particular social group of individuals who had been subject to domestic violence. Another one was that the country in question would not actually protect her from that. This was an exception that swallowed the rule. So in a broad variety of cases, actually every case more or less that came down the pike that involved domestic violence from a Northern Triangle country, domestic violence was recognized as a particular social group, notwithstanding the fact that ICE did not actually make those concessions at the hearing. A few months ago, in a case called Matter of AB, Attorney General Jeff Sessions attempted to return order to the membership in a particular social group category. What he said was individuals who are members of common criminality, individuals who suffer from crime, are not actually members of a particular social group without more. It's the same standard that we apply to particular social group generally. Remember, whatever you identify as your particular social group has to be at least one central reason for why you were harmed. The other thing that he said, and this is case law that's existed for decades, the particular social group has to exist outside of the persecution alleged. The persecution itself cannot define the social group. I cannot be a member of the particular social group of individuals who were mugged, because I had to have been mugged in order for me to have been in that social group. But if the mugging is the persecution that I'm alleging, it doesn't count. So many people said that that Attorney General Sessions was creating new law, but in reality what he was doing was he was applying prevailing law to a situation that had gotten out of control. I'm going to skip around for just a very brief moment before we return to this subject and put it into the border context. In expedited removal, we no longer have to go through the system of going before an immigration judge for that category of individuals who either don't have visas who have engaged in fraud or who have entered the United States illegally. We can just move them right out of the United States. Dan Cadman will tell you what it used to be like back in the old days when people would pour over the border in the millions and we would have to put them all through removal proceedings. Courts were swamped with people who really didn't have any right to be in the United States, but we had to go through the process. There would be a gate on one side of the Mexican border, and it would lead right into Mexico. The courtroom would be here, you'd be ordered removed, you would waive appeal, and you'd be sent back. But at least you got to see a judge. Congress in '96 didn't end run around that. If an immigration officer determines that a person is either here through fraud because they don't have a proper document or because they entered illegally, they can be expedited removed. With respect to that last category of people, Congress said, you, Attorney General, now Secretary of Homeland Security, can apply this rule to anybody in the United States for less than 2 years. If you entered illegally and you've been here for less than 2 years, you could be subject to expedited removal. In 2005, in a regulation that's never actually been more than published in the Federal Register, the Secretary of Homeland Security at the time, Tom Ridge, I think, said, no, we're only going to apply this to people who were apprehended within 14 days of entry and 100 miles of the border. So notwithstanding the fact that we could do it for anybody who's been here illegally for 2 years, it's now only 14 days and 100 miles of the border. So if Border Patrol picks you up near the border, Border Patrol can put you into expedited removal proceedings. For years, this system worked really well, up until about 2005. So from 1996 till 2005, the system worked great. And then it started to break down. And then it really started to break down. Because there's an exception to the expedited removal rule. And that is in order to comply with the 1967 Protocol to the 1951 Refugee Convention. Before we can turn you around and send you back home, we have to make sure that you don't have an asylum claim. Up until about 2009, about 5,000 people a year said, I have a credible fear of persecution. That's the standard that we use, credible fear of persecution, in order to comply with the 1967 Protocol to the 1951 Refugee Convention. It's a very low standard. It's a screening standard that we use to make sure that anybody who has an asylum claim doesn't accidentally fall through the cracks and get sent back to what we call refoulement, persecution. By the end of the Obama administration, about 80,000 people were making credible fear claims. This year, the number may actually be higher. I haven't seen the final numbers yet for the number of people who have made credible fear claims because they're only through June published thus far, notwithstanding the fact that we're in a brand new fiscal year. So many people know that if they show up at the border and they say, I'm going to be persecuted, I'm going to be harmed, I need credible fear, that we have a huge number of people who are doing it, which has undermined that expedited removal proceedings. Expedited removal was supposed to be a way to move people out of the United States quickly. It's now been turned on its head. It's now become a way for people who have entered the United States illegally to get to remain in the country. Why is that? A couple reasons. One is the credible fear standard is very low. Credible fear is found in about 75 to 90% of all cases in which a alien subject to expedited removal is interviewed by an asylum officer. Why is that standard? Why so many people? One, standard's low. Two, by law, you don't need to provide any documents to establish that you have a credible fear claim. Your credible testimony is sufficient. Asylum officers are amazingly overworked. 520 people to deal with 80,000. Give you an idea of how, plus 142,000 people who have applied for affirmative asylum in the United States. That'll give you an idea of why it's so low, or why it's so high. The other reason is that notwithstanding the fact that Congress never said we want you to consider whether people have a credible fear of torture, after we acceded to the Torture Convention, we began to apply a credible fear of torture. Therefore, if you say, I'm going to be tortured if you send me back home, you'll be interviewed. The asylum officer will likely pass you along to an immigration judge. That's what happens, by the way. If you pass credible fear, you get put into removal proceedings before an immigration judge, and you're able to make an asylum claim or any other claim that you want. You're not actually limited to making an asylum claim before an immigration judge. That's the credible fear system. 75 to 90%. Why 75 to 90%? 75% of all cases, a whole bunch of those people end up getting their cases closed, either because they withdraw their application or because they're eligible for something else or because the United States government decides to do something different with them. About 90% of all cases that are decided, actually 89% in the last couple of quarters, have been found to have credible fear. So again, very low standard, very low evidentiary standard. A lot of people get to use this system. That's why you get tens of thousands of people. Well, who are these people? A lot of them are adult males. However, adult males can be detained. We have plenty of detention space for adult males in the United States. We don't have plenty of detention space for families. For that reason, we've seen a huge influx in the number of families who come to the United States. Families with children. There are very few family detention centers in the United States, very few beds that are available. So if you show up with your kid, you're probably not going to be detained very long. It's going to be your passport into the United States. It's not just simply a logistical issue. It's not just simply that we don't care enough to build more family detention space. Who here is familiar with the Flores Settlement Agreement? Anyone? I know you are. You don't count. You know it. You know it. You know it. Young Ms. Flores was the named plaintiff in a class action suit that began in the early 90s and concluded in 1997. Ms. Flores is now 47 years old, to give you an idea of how long this case has been vexing the American immigration system. Under the Flores Settlement Agreement, as recently interpreted by the Court of Appeals for the Ninth Circuit back in 2016, we can only hold alien minors, DHS can only hold alien minors for 20 days. And the Flores Settlement Agreement doesn't just apply to unaccompanied alien children. It applies to ones who show up with their families too. Why? Plain interpretation of a 21-year-old settlement agreement. Not because we've decided it's right or we've decided it's just or it has to be done. It was a plain reading by the Ninth Circuit. They said, well, we don't see anything here that says unaccompanied alien children, so we're just going to apply it to everybody. What happens? You got two choices. One, we can release families. 20 days have gone by, we're not going to hold you anymore. You get released. Mom, dad, kid, or dad and kid, or mom and kid. Or alternatively, we can separate families. Stop me if separation of families sounds familiar to you. So, what DHS is doing right now is they're releasing almost every family that shows up because they don't want the bad PR and because they don't have enough space to hold people. So we've talked about alien minors generally. Let's talk about unaccompanied alien children. Section 462 of the Homeland Security Act. I'll never forget this moment. I was there. I was in the room. Anybody who's ever been a staffer has had this moment where they know that something really bad happened that's going to have a horrible effect later, but sounds perfectly fine when you're there. So Lofgren of California offered an amendment to the Homeland Security Act that said unaccompanied alien children should not be detained by DHS. They should go to HHS within 48 hours. And they should be held, actually, they should go to HHS. Seems reasonable, except for the fact that if you look at HHS's charter, it has to do with Health and Human Services, for those of you who are not in the know, but we're all in D.C. It talks about ensuring the health and welfare of the American people, but doesn't mention anything at all about detaining alien children, even 16 years after the fact. Their mission statement has not been changed. So anyway, years go by, the Democrats take over the House and the Senate. It comes time to amend the Trafficking Victims Protection Act. The William Wilberforce Trafficking Victims Protection Act is known as the TVPRA. And it said that unaccompanied alien children could only be held by DHS for 48 hours and that they had to be released into the least restrictive conditions possible. Which means that unless you are an alien minor criminal or a gang member, you're probably going to a family member in the United States. Many parents were in the United States, they'd entered the United States illegally, and they left their children with their brothers or sisters or with their parents, and they would send money back. 2008, the TVPRA, we don't have to worry about that anymore. HHS is actually going to deliver our children to our doorstep. How perfect! This is great. All we got to do is pay a smuggler to get you to the border, and then the United States government is going to complete the job of the smuggler. I didn't say that. U.S. District Court Judge Andrew Hannon said that. Although I just repeated it. So, good idea, poorly thought out. The eventual ramifications of it, not very well thought out. Consequently, guess what else we see a lot of in credible fear proceedings? A lot of unaccompanied alien children show up at the border of the United States. 2014, we saw a wave, 60,000. 2016, we saw another wave of unaccompanied alien children show up in the United States, most of whom had been paid for by their parents to come to the United States, to be reunited. Or alternatively, they were sent ahead. Maybe you'll get something. Maybe you can go make money and send it back to us. Or you can bring us to the United States someday. So, we see a lot of them. Why is this a problem? Why does it matter? Who cares? Okay, we got a bunch of families and a bunch of kids. There are two reasons why, and I'm going to give you the operational reason, and then I'm going to give you the visceral reason. The operational reason is every time that a family unit shows up at the border illegally, every time the non-accompanied alien child shows up at the border illegally, we have to pull Border Patrol agents off the line. We got about 18,900 Border Patrol agents in the United States. That includes 5,496 miles of Canada and 1,990 miles of border with Mexico. 18,900 people. And we know the government employees do two things. They work 40-hour weeks and they get a lot of leave. Most of those 18,900 Border Patrol agents are not on the line at any given time. When a family unit shows up, we have to pull those people off of the line. Why is that a problem? Because on the other side of the border are spotters. If you've ever been to the border, if you've ever been to the Rio Grande, if you've ever been to the desert, if you've ever been to Sonora, if you've ever been to San Ysidro, you know that there are people up in the hills or across the way who are watching everything that goes on along the border. So, whenever they see the Border Patrol agents are pulled off of the line, what they do is they send whatever they're selling across the line. Heroin, opioids last year accounted for $115 billion cost to our economy and 48,000 people dead. Almost all of that was attributable to heroin and fentanyl as well as some prescription drugs. When marijuana became legal in most of the United States, notwithstanding 21 United States Code 841A1, which says that selling marijuana is a federal offense that will get you a bunch of years in jail, the drug cartels were in real tough shape because they made a lot of money moving hoochie scooch across the border. By the way, hoochie scooch is slang back in 1980 for marijuana. All of a sudden, they were out of that business. Colorado put them out of business. So they had to figure out what else to do. In the state of Guerrero, they realized that it's really easy to grow poppies. It's really easy to process poppies into heroin. Mexico is now the largest heroin producer for the United States by a factor of 9. So, Whenever a family shows up, we pull Border Patrol agents off the line. We move that across. Methamphetamine, in the United States, if I have a cold and I go down to my CVS, I have to show my driver's license to get a box of Sudafed. That doesn't happen in Mexico. You can buy as much Sudafed in Mexico as you want, and you don't need to grow anything. You just need Walter White to mix that up for you, and you're done. Major producer, the largest producer of methamphetamine in the United States. In addition, we also are moving people through. Smuggling gangs see families go through, they then move other people through. Trafficking victims. Trafficking is a horrible thing. Worst thing you can imagine. In my courtroom every day, every week, I would see the same thing. I would see older women from China who were picked up at various establishments in Pennsylvania, and they just happened to be waiting there for a friend. Massage parlors staffed by individuals who were smuggled, trafficked into the United States so that they can pay off the $70,000 debt to the snakeheads. Horrible way to live life. That is the operational reason. I'm going to give you the actual visceral reason why we want to stop that flow of unaccompanied alien children and families to the border. 10% of all women who make that trip are going to be raped. About 2 to 3 times more are going to be sexually assaulted. About 7% of all men who make that journey are going to be raped. 2/3 of all people who make that journey are going to be assaulted in some way. 7% are going to get shot. If you can imagine that you undertake a journey and the odds are just less than 10% that you're going to end up with a bullet in you. Not really something that we want to promote. Curiously enough, though, the drug smugglers never tell you this at the time that they take your money in San Pedro Sula or Tucunaman or in Altar, Sonora. If you go to Altar, Sonora, there's a specific pharmacy, by the way, that I can point you to where you can go and get the shot that will provide you with birth control for a month. That's how common rape is, and that's how commonly known that it will occur. That's really that in a nutshell. Mark's going to come and he's going to talk about the caravan. He's going to talk about all that. But that'll give you the background. Asylum, expedited removal, credible fear, unaccompanied alien children, the Flores Settlement Agreement. There's nothing we can do to stop them. Not right now. Not unless something changes. One thing with Flores, by the way, DHS has promulgated regulations. They will close on November the 6th that will actually end Flores. And it'll end Flores because Flores was never supposed to go on for 21 years. The Department of Justice was supposed to promulgate regulations that were going to actually set standards for facilities. One of the biggest issues that we have with respect to detaining family units is, in the United States, we don't detain children with their parents when they go to jail. So there are no state standards for family detention. However, the Flores Settlement Agreement says, well, you need to follow the state standards for family detention, which don't exist! Except in Pennsylvania, because they have the Burke's Family Shelter. So DHS is going to follow the Pennsylvania standards for family detention and apply those across the board if those regulations go into effect, and then we can make this a lot bigger. We can actually have more family detention. The more detention we have, the less likely you are to come to the United States. So you're coming to the United States to live here. And by the way, when I was a judge, 99% of the people that I saw came to the United States to work illegally. Nobody ever said, oh, I came here because I want to get welfare, because you can't. They came here to work. If you can't be at large in the United States and you can't work, you're not going to come. You're not going to run a 10% risk that you're going to get raped. You're not going to run a 10% risk that you're going to get shot. You're not going to run a 66% chance that you're going to be assaulted. You're just not going to.